For 11 years, I was a faculty member at Harvard Business School. I met and exceeded the school's high standards for research and teaching. I loved my work, and I won high praise from colleagues and students for my contributions to multiple academic fields, for teaching, and for my service to the school. I looked forward to continuing my work at HBS for the foreseeable future. My promotion to tenure was derailed by improper disciplinary proceedings that ran roughshod over the governing rules that, as it turns out, were created especially for me. That led me to file a lawsuit in spring 2023, and there's recently been a major development. Both Harvard and I filed summary judgment papers, in which each side says it should win. Harvard says it should win completely. I say I should win on one of my 3 claims, without waiting for trial. Summary judgment entails showing the evidence each side says should make it win. And there's a lot of evidence, more than 1,000 pages across 186 documents in the joint appendix. This screen shows about 1/6 of the evidence. Let me just scroll through it for you. Yeah, that's a lot of evidence. So we're not going to be able to read through all of it together. Instead, I'm going to tell you about some key themes, what I think is important. This is no substitute for reading the underlying litigation documents and my prose reflections, but if you like voice and visuals, stick around. Up until 2014, I had always been well liked at HBS. My research was excellent, well read, timely, and I'd like to think impactful. My teaching was honestly just okay. I'd say average by HBS's extraordinarily high standards. I got better later. In 2014, yes, 2014, I got myself into some trouble. All very easily found on the web if you take a moment to look. First, I'd been writing for more than a decade about an adware program first called 180 Solutions, then Zango, then Blinks. Maybe you had the displeasure of having some of this junk on your computer. It was adware, to put it generously. Well, some investors asked me for an update. I was surprised by what I found. I was troubled by what I found. I later published an online article based on that update, and the stock frankly plummeted. Some people thought I was a tool of the investors. Second, a restaurant near my home had been advertising one set of prices on its website and charging more when customers arrived to pick up their takeout. I thought they were doing it on purpose. I complained to my city government, which in turn asked the restaurant about it. The restaurant got mad and gave the world my emails, and most people thought I was a big jerk. To all of that, some at HBS got pretty angry at me. I was bringing the school bad PR. People didn't like that. No doubt some wanted me kicked out then and there. But how? What policy had I broken exactly? These were my outside activities using my personal email, the former on my personal website, not using my HBS affiliation, which, to be sure, people could find by web search. It just wasn't obvious how they'd force me out. They decided to create a new review process, really a disciplinary process. I always suspected they created it specifically for me, and with litigation documents, I can prove it. Here's Summary Judgment Exhibit 101, Deposition Exhibit 193, numbers only lawyers can love. It's an email between 2 staff members at HBS discussing a meeting one of them had with Nitin Noria, then the dean. Nitin and I spoke yesterday about launching a review process for Ben. A new process, yes, for me, yes, created exactly with me in mind. Other notes say the same thing. From Cunningham's notes of a meeting about the new process. Objective 1, first thing on her list is, quote, respond to the Ben Edelman situation in particular. They called the resulting process the Faculty Review Board. It follows a 4-page set of rules, the Principles and Procedures, or P&P for short. The rules were circulated to the entire faculty, discussed and approved. In my view, the rules are quite good, fair, or frankly more than fair to a person accused. One of the P&P rules is a requirement to provide the faculty member under review with, quote, the evidence gathered. Here's what the rules say. The draft report, quote, should include the evidence gathered. Okay, that sounds a little tentative, but look down 4 lines. Will. The report should include evidence, but the faculty member will get to see the evidence. Not just should. No matter what. Nice. That's good for me. I should mention that in litigation, Harvard says they aren't bound by this provision, or by any of the P&P. They say the FRB P&P rule sheet did not create a contract, they say, just principles, they say. I reply to that, I think convincingly. Harvard announced the P&P to faculty, asked faculty to discuss it, and then acted as if it was bound. They sent the P&P to me repeatedly, twice that I can find in the emails. Of course, they had designed this process with me in mind from the start. With all of that in mind, I say, under the case law, yeah, it's a contract and I'm entitled to it. But more than just acting as if it was bound, FRB leaders groaned and did what the P&P said they had to do, even when they didn't want to. Here's FRB Chair Amy Edmondson emailing a colleague about an FRB procedure she wishes didn't apply. She says, "It's unfortunate that the P&P gives me a chance to respond to the FRB's draft report. If the P&P was optional and non-contractual, as Harvard argues, she could have just decided not to do what it instructs, since after all it would just be, an optional suggestion. Instead, she lamented the rights that I had. But to her credit, at least she did do what the rule said, because she knew at the time that the P&P was binding. It's only now in litigation that Harvard's lawyers claim the P&P didn't apply. It obviously did. Well, I say it did. We'll see what the judge says." So back to the evidence gathered. Did the FRB actually give me the evidence they gathered? No. They interviewed 21 witnesses. They took notes of all the interviews. They gathered and discussed various other documents too. They shared none of this with me. No email forwards, not even as attachments to their draft report. Nothing. If the FRB handled all the evidence properly, maybe it wouldn't matter whether they gave me the evidence. But there's judgment here, an obvious risk of the FRB skewing the evidence in a way that brings the reader where they want to go. I was supposed to get the evidence so I could use it, so I could put on a real defense, the best defense. And as I cross-checked the evidence with the report, I was shocked by what I found. I mentioned witness interviews, and the FRB used those interviews for a section of its 2017 report about my quote-unquote respect for others inside of HBS. There, they offered dozens of positive remarks like these, and there are lots more. It's 27 positive remarks in total. But then the FRB shifts to negative quotes. There are 13 of these in the FRB's final report. During litigation, I went through them carefully to figure out who said what. Here's the one that most bugged me. This is suggesting that I'm respectful to senior colleagues but mean to staff? That is completely nuts. If anything, I have a bit of an anti-authority streak. The first time I met Dean Noria one-on-one, I told them about a serious copyright matter where the school was taking rights from faculty in violation of university policy. I don't think he took offense. The school ultimately realized I was right and made a significant change. But it's just not true that I talk down to people below me. I try to be an equal opportunity straight shooter. Well, with the benefit of the evidence I got in litigation, evidence the FRB, of course, withheld during the review of me in 2017, I found where this quote came from. Here's the underlying interview notes from an interview conducted by FRB member Stu Gilson. The first thing in the notes is that what follows is, quote, second/third hand. That means it's unreliable. Now, the FRB had actually discussed rules for interviews, and these were supposed to be interviews based on witnesses' firsthand knowledge. Maybe Gilson should have stopped the witness right there and said, hey, we only want firsthand information. Certainly Cunningham, when she excerpted these interview notes to write the FRB's report about me, should have recognized the problem. But it gets worse. 4 lines down, there's the line that was in the report, as we all probably do, is added right after. Well, think about that. This appendage totally changes the meaning. The witness is not saying he thinks that I'm disrespectful to staff. He's saying that if other people say that, which he's heard second or third hand, they're confused because really everyone is kind of like that. He thinks I'm fine, in fact, better than fine. The FRB's selected excerpting changed the meaning. Obviously, if I had had the evidence, these interview notes, I would have used them to rebut, really to demolish the FRB's incorrect claim here. So here we see a first example of how right the P&P was to insist that I get the evidence gathered. Just to check what the witness really thought, and we wanted some remarks from him on other subjects anyway, we took his deposition. I can tell you his name here because it's revealed in the litigation documents. The witness is Josh Koval, a senior faculty member at HBS, and what he actually said about me in his own words, not distilled through Gilson's notes and Cunningham selected excerpting, is that my heart was in the right place, doing all the right things. He continues, all positive, every word. The whole deposition. It's posted in relevant part in my litigation documents exhibits. From that, somehow the FRB twisted it around into criticism of me for all things being disrespectful to staff. If there was any evidence for it, it certainly wasn't Josh Koval's interview. What a mess. Thing is, that selective excerpting is just one of many examples in the documents. Here's another. In this one, I guess I can more readily recognize myself. Yes, I'm sometimes direct. I'm not ashamed of that. There's so much beating around the bush in the world. Often I'd rather just get to the point. But who said this? And did they really think that some aspect of me being direct was grounds for me to be fired? Well, I found the interview notes, which had this paragraph. Notice what's in red, continuing the quote. Again, selective excerpting, taking out this important continuation. And again, the continuation changes the meaning. If I were abrupt and lack grace, it sounds like the witness thinks I'm a bad guy. But combine that with sharp, asking great questions, accepting alternative arguments, and agreeing to disagree, it's clear that this witness actually thinks I'm fine, or better than fine. In an interrogatory, Harvard asked me last year how I would have used the evidence opposing these quotes. I provided an 8-page answer, going through the quotes one by one and explaining what was wrong with each one. Here's what I said in that answer about the quote discussed on the prior screen. And yes, there are about a dozen other blocks going through the other quotes in comparable detail. Check them out. I said there were 13 negative quotes, and for most of them, there are problems a lot like what I described in the last few minutes. Problems like selective excerpts and witnesses talking about what they heard second and third hand. But 2 have even worse problems. You read through all the evidence gathered, all the interview notes, and these 2 quotes just aren't there. They're not anywhere. So I went through the various versions of the FRB draft report about me. Remember, in Discovery, I get the emails, at least the emails that the FRB members didn't delete or destroy. More on that later. Often, the emails attached interim drafts of the FRB's report. And so I found where Angela Crispy, Executive Dean for Administration at HBS, the highest ranking staff person in the dean's only non-faculty report, every other staff person on the whole campus, from the secretaries to the IT staff to the landscapers, they all report through her. Well, she had inserted these 2 quotes. So my attorneys asked her in a deposition, where did these quotes come from? Over and over. And to my surprise, she denied that these insertions were even supposed to be quotes. Not here as a direct quote. Not direct quotes. These aren't direct quotes. So they weren't quotes, huh? Okay, well, there are no quotation marks on the left side. It's true. This bulleted list, it's kind of weird. I think of it as sort of like a indented block quote, when, of course, in a block quote, that's still a quote, even though you don't use quotation marks. The indentation serves the same purpose. Here, we have indentation for the bullets. So are they quotes or not? I guess a little bit hard to tell. You can look at the introduction words like noted and expressed as. Does that mean they're quotes? Things that people actually said? Well, for an additional insight, we can look at the email where Angela Crispy inserted these quotes and told colleagues what she had added. Here's what she said at the time. Yeah, she called them quotes. And her deposition really doesn't offer any way to reconcile what she said at the time with her new story for litigation. But Crispy wasn't the only person who thought these were quotes. FRB Chair Edmondson discussed, quote, the quotes. FRB member Len Schlesinger discussed the quotes. And Dean Noria's handwritten notes refer to, quote, quotes. They all thought they were quotes. Harvard ultimately dug up some emails where someone had written something with some of the words in the 2 quote-unquote quotes that aren't quotes at all. But, of course, the words aren't quite a match. In fact, they're not all that close. And while Crispy's transmission email says the quotes are, quote, from my interviews, copying from an email wouldn't be an interview at all, would it? FRB members had agreed on a specific interview protocol, the questions they were supposed to ask, how they were supposed to ask them, and of course to do it orally in, yes, an interview. Email is just not that. To be kind, this is all kind of sloppy. Actually, I think it's a lot worse than sloppy. My litigation documents called it fabrication, and I think the word is appropriate. Students are suspended and journalists fired for falsifying quotes. Here, my career hung in the balance. The FRB just should have done better. My court filings also remark on the thin evidence supporting the FRB's findings against me. Criticizing me for supposed tensions with staff, one might think they must have interviewed, 6 staff or 10? Edmondson's instructions to Crispy had been to interview the CIO plus 1 to 2 other IT representatives. But no, Crispy interviewed just 4 staff, including 1 from IT, not 2 to 3, not the CIO. That's a fraction of what Edmondson had instructed. Readers of the FRB's report had no way to know that the criticism of me rested on such thin evidence. Of course, if the FRB had shared the evidence with me as the P&P required, I would have made that point forcefully. The evidence gathered would have been useful for a further reason. Some witnesses praised me in the strongest possible terms. With my character under attack, I would have used this to try to clear my name. Here are some highlights. Frankly, it's awkward to show these. What am I, tooting my own horn? But in the FRB proceedings, I needed it. I needed every bit of help I could get, given what I was up against. I certainly would have used these. My allies would have used these, my supporters, frankly, my friends. This should have been provided to me so that I could have used it to the utmost. Let me change gears now from the evidence gathered to some other P&P violations. The P&P uses the word, quote, allegation 11 times, demonstrating the centrality of that requirement. The P&P is clear. The FRP must write an allegation and must send it to the person under review. In case there were any doubt of the importance of an allegation, check out Cunningham's handwritten notes from when she was designing the FRB. She said a, quote, allegation was the first of two, quote, key elements for an FRB. So did the FRB provide me with an allegation in 2017? Here's what FRB Chair Amy Edmondson said in a deposition. She said, no, not that she knew of. And what the FRB actually sent me in lieu of an allegation was at best, what, an agenda. But that won't do. An allegation means a claim of wrongdoing. This agenda is something like a personality test, a gathering of opinions. The P&P says the FRB has to determine whether misconduct has occurred. Determining whether misconduct occurs requires, yes, an allegation of a specific person doing or not doing a specific thing that they were supposed to do or not do at a specific time. Let's pause for a second to talk about the timeline. The FRB actually investigated me twice. In 2015, they looked at the Blinks and restaurant matters I mentioned and some internal HBS stuff that you can read about on my website if you're interested. HBS decided to extend my appointment, and somehow they ended up convening a second FRB. This case is entirely about the second FRB. That's when I say HBS breached its contractual obligations. And specifically, I want to look at whether the second FRB stated an allegation, as I say the P&P required. Well, as Edmondson admitted when she said, not that I know of, and as the letter's 3 bullets make awfully clear, recall the prior slide, whatever they sent me, it was not an allegation. To that, Harvard says the P&P's requirement of an allegation doesn't apply because the 2017 FRB was a, quote, reconvening of the 2015 FRB. But the P&P says the FRB will prepare a draft report, one singular. The 2015 FRB prepared its report. 2017 is a new FRB. It prepares its own report. And yes, that means it needs its own new allegation. Contemporaneous documents are in accord. HBS called the 2015 and 2017 FRBs reviews, plural. In deposition, Dean Healy called the 2017 FRB review, quote, another review. Noria used the term another review twice. Look, it was plainly a second FRB. Separate membership, separate opening letter, separate report. It should have stated an allegation at the outset. It didn't. That's a violation. And it's an important violation. They really didn't have an allegation at the start of the 2017 proceedings. So if they had to state an allegation, they would have had to admit that they had none and stop right there. Or if they had somehow stated an allegation, they would have been confined to that, an orderly, careful procedure, when what they actually did was the opposite, as we'll see in a moment. 22 days after the FRB finished witness interviews, 18 days after the FRB interviewed me, the FRB contacted me to dramatically expand its scope. Previously, they said they wanted to look at changed behavior, which isn't an allegation, but okay. Now they want to know all my outside activities, all my work products, and then a memo of reflections about how I thought about my outside activities. That's a major change in what was asked of me. And how long did I get to submit? 4 business days. A big change from the FRB's norms. HBS promotion processes are usually methodical and frankly slow, timelines of weeks or even months. Suddenly, they told me I had to hustle. Behind the scenes, it turns out that FRB staff member Jean Cunningham was not confident in the proposed expansion. When others suggested expanding the FRB scope, she remarked that it was outside the purview of the current FRB mandate and also a new allegation, which she knew was totally untimely. As Harvard tells it, Cunningham's message was tentative and uncertain, and she ultimately changed her mind about all of that. But the fact that she, the author of the P&P and the FRB's sole staff, the fact that she thought so, it's informative. She thought the rules made this audition untimely. I say she was absolutely right about that. Cunningham also flags that the email the FRB had just received, the impetus for this reply, was, quote, in effect an allegation, paragraph 2, sentence 1. Indeed, by this point, the FRB did have an allegation that I had supposedly omitted certain disclosures that were supposedly required from certain publications. The amazing thing here is that despite Cunningham recognizing that the FRB finally did have a 2017 allegation to investigate, they never told me. They could have stopped and alerted me that they had an allegation to add, or at best clarified their initial letter. No, they kept this to themselves, obviously not allowed under the P&P. It was only when I received the FRB's draft 2017 report, this time with 6 business days to reply, that I found out what allegation they had been working on behind the scenes. They said my writings about Google should have included disclosures of work with Microsoft. Okay, so now we finally at least have an allegation to discuss. It could be right, it could be wrong, but at least it's something. Well, it turns out this allegation is totally messed up. The most glaring reason why it's messed up is that the HBS conflict of interest policy, in its wisdom, only requires disclosures in a specific circumstance where a person both has a material financial relationship with a company and writes about that company. You could imagine a different policy. Maybe there could have been faculty consensus for a different policy, but I was always struck how hard it was to get faculty consensus on COI issues. Anyway, this is the policy we've got. This is the policy they should have been applying to me. Well, the FRB was criticizing me for writings about Google, but they didn't claim that I had done work for Google or had a material financial relationship with Google. No, the alleged basis of my conflict was work for Microsoft. Now, that was work as an attorney, so I can't say what it was about. But no matter what it was about, even if it was Microsoft suing Google for antitrust violations, which it most certainly was not, that still would not violate this policy. Under the COI policy that they actually enacted, only work for Google would be, quote, directly related and would require a disclosure in a writing about Google. Everything else is a judgment call, not a violation of this policy. Personally, I always thought the COI policy was much too narrow. Years before the COI policy took effect, I made it my practice to disclose quite a bit more, including to disclose my work for Microsoft anytime I wrote a piece about Google practices relating to competition, and sometimes when writing about other Google practices too. So if I wrote a piece about Google violating competition law, as I saw it, yes, I disclosed that I had worked for Microsoft, whether or not that work was actually related. So far as I know, I did that on every work product every single time, starting when I began working with Microsoft and ending when I stopped working with Microsoft. And here we get to another amazing fact. My work for Microsoft ended in October 2015, about 2 years before the FRB's 2017 report. The alleged conflict, such as it was a conflict between current writings and past consulting, not current writings and current consulting. The FRB didn't seem to know that and certainly didn't mention it in their report. I made these points in my reply, both the limited directly related rule and how it didn't apply to my situation, and also the Microsoft work having ended years earlier. You might think this would be a perfect circumstance for the FRB to revise. After all, they had sent me a draft report, which they were going to revise to make their final report. So if they learned some important fact, like, wow, these two things weren't even happening at the same time, and there's a serious question whether the COI policy applies, maybe they'd want to tell readers that, so that a reader who only reads the FRB report and doesn't read my reply would get a fair sense of what actually happened. Crickets. No, they changed none of that. They wanted it to sound like I had broken the COI policy, which I had not. And they wanted to make it sound like the Google writings, without disclosure, and Microsoft Consulting were at the same time, which they were not. That's where I got in my 6 days to reply to the FRB's draft report, because I also had a lot of other material to reply to, such as the anonymous decontextualized quotes I discussed earlier in these remarks. But litigation brought an opportunity to dive into the 6 work products where the FRB said I was out of line. Let me tell you about my favorite one, an article I published in the Harvard Business Review in April 2016, along with my co-author Damien Gerardine, a distinguished competition lawyer based in Brussels. We looked at the problem of companies that break one or more laws and get, frankly, a big advantage from that. We had some obvious examples. You wouldn't say Uber or Airbnb got their start by spick and span compliance with every law under the sun, kind of the opposite, actually. So we explored the question of how competitors and policymakers should think about this problem. I find it a genuinely interesting question. I hope you will too. Well, in passing, in exactly 3 paragraphs of this 7-page piece, we mention YouTube. We discussed YouTube's practices before Google acquired it. The FRB's argument, I think, is that because Google later acquired YouTube, I should have disclosed here that I had done some work for Microsoft at some point, of course, well after Google acquired YouTube, though not recently. The timing is messy, to put it mildly. So that's one problem with the FRB's argument as to this piece. Discussing a company that another company acquired that in turn went on to compete with a third company where I had done some work a while before. Yeah, we're way beyond directly related as any normal person would use that term or as the policy defines it. But there's an even bigger problem with the FRB's argument about this HBR article. I told my HBR editor that the piece mentions YouTube, and I suggested that a disclosure would be appropriate. Here's my comment from the margin of the file in Word, screenshotted and copied in for your pleasure. I specifically asked my editor if there's, quote, room for another sentence to mention the work for Microsoft. In his wisdom, he chose the generic disclosure that was ultimately published in the article. Now, he had his reasons. He liked generic disclosures because when I published on HBR.org, HBR's IT platform needed a single disclosure for every article, not a separate disclosure for each article, mentioning the things that were relevant there. But look, I told him, he's a Harvard employee. His job is to make decisions like this. He did what he felt was right, and incidentally, he correctly applied the HBR journal policy, which, just like the HBS COI policy, only applies if an author worked for the very company that appears as an example in an article. Under the HBR policy, just like the COI policy, competitors don't count. My affidavit in support of my motion for partial summary judgment discusses the disclosures at length, 6 pages, pages 5 to 10. It culminates with this table. I present the 2 arguments that were offered in my reply to the FRB, which apply to all 6 work products, but I also have 7 other arguments that collectively apply to all 6 of the work products. I had to go back and read the drafting, the correspondence with the editors, find the journal policies. It was a lot of work to make this table, a lot of work to figure it out, totally unrealistic for 6 business days, especially when I had the rest of my reply to draft in that same period. The FRB's allegations on this subject were just so messed up. That's the peril of them rushing, and sadly, me also rushing in my reply. That brings us back to the PNP's call for an orderly process without late additions. One more violation of PNP. The PNP required an FRB to, quote, investigate and, quote, reach conclusions. You might think that's automatic. I mean, certainly the interviewed witnesses, they read documents, they discussed. That sounds a lot like investigating. And how could you write a report without reaching conclusions? Indeed, in its opposition to my motion for summary judgment, Harvard makes exactly these arguments. The thing is, for better or worse, the FRB's report leads on its page 1 with an admission that it was, quote, not an investigation and, quote, did not seek to pass judgment. If it's not an investigation, then can they say they, quote unquote, investigated as the PNP required? If it's not an investigation, doesn't that mean they didn't investigate? If they didn't, quote, pass judgment, did they reach conclusions? How could you reach conclusions without passing judgment? The things are one and the same. Now, you could write off this as just fluff, just filler, words with no meaning. I'm not sure I'm prepared to say there are any words in the FRB's report that don't have meaning. Furthermore, the FRB members are 3 serious scholars, all tenured at Harvard. They know what good writing is. They know what an investigation is. They know what it means to apply a policy to the facts. And they knew that they didn't do it. I read this paragraph as an apology for a report that they knew would be criticized. The report wasn't quite right. But 2, they're absolutely right. The nature of their work did not lend itself to being a true investigation because they didn't begin with an allegation to investigate. And to the extent that they had finally ended up with such an allegation, they didn't actually apply the applicable policy to the facts. They didn't discuss what exactly the COI policy actually required, what clause says what situations it covers and doesn't cover. That would have been some work. It would have been lawyerly work. Maybe they would have needed a lawyer to help them. They didn't do it. My legal filing remarks that they didn't, and I don't understand how they could possibly say they did. In a widely read Twitter thread last month, Bill Ackman remarked on his concern at HBS sanctioning and eventually firing Professor Francesca Gino, in large part, as he tells it, because HBS perceived too much reputational risk, PR risk really, in fairly investigating a professor whose story was bound to create a media sensation. He's surely right that Gino's story was made for the headlines, allegations against a researcher who was studying honesty. And he offers a cogent theory of why HBS would bend and break its rules as it investigated her. In some ways, the FRB shows a similar PR focus in its approach to me. Here are 4 quotes from the FRB's report about me. There's no question that the 2014 media incidents were damaging to me, and somewhat damaging to HBS too. But however bad this was, it just wasn't a factor the FRB was tasked with evaluating. The PNP didn't authorize them to do it, and it's not clear how it could be done within the evidence-based framework that the PNP specifies. There's just too much subjectivity. I'm not going to find instances of misconduct here. Whatever it is, it's something else. The subject, such as it was, should have been left to the full HBS Appointments Committee. Not just because that would have been more fair to me, although it would, but because the PNP simply did not authorize the FRB to look at this subject. So far, I've been telling you about claims grounded in the PNP, where the PNP said the FRB had to do something and they didn't. These are contract claims, and this is what I have sought summary judgment on, where I say I have proven violations and I can win right now without a trial. But my case has another set of claims too. Every contract includes an implied covenant of good faith and fair dealing. This disallows one party from a contract from doing something that prevents the other from getting the benefits of the contract, even if the thing the other party did is not specifically prohibited by the black letter of the contract. Via discovery, I now stand prepared to prove quite a few violations of the duty of good faith. There's a lot in my legal filings. Let me show you my favorite. In 2015, FRB members discussed and memorialized in their notes the prospect of getting me to leave HBS voluntarily by putting a structure of resources in place that I would, quote, find onerous and leave. In the FRB's first meeting in 2017, before the FRB collected a single piece of evidence, FRB member Stu Gilson said that I had, quote, priors, that blinks alone should have been enough to fire me. He was seething, and he said I was irredeemable. Wow, irredeemable. If I'm irredeemable, what are we even doing with this whole FRB process? Meanwhile, FRB Chair Amy Edmondson said, at some level, it's obvious that we shouldn't have him on the senior faculty. Again, if it's obvious, why go through this process? Is that really what I had signed on to? Is that what the school instructed? All of this, of course, before collecting a single piece of evidence in 2017. These internal communications undermine Harvard's claim of a legitimate process in 2017. Stating these views, having these views before the process began, the FRB members revealed their predetermined conclusion. That denied me the fair evidence-backed proceeding that was contemplated by the PNP. Let me do destruction of evidence in a single slide. Various Harvard leaders realized pretty early that the FRBs about me could lead to litigation. Here's the clearest, a May 2018 email from Dean Healy to Dean Noria saying that I am, quote, seriously considering suing. He was right. That's what I had told him the same day. His email should have caused HBS to preserve documents and emails, turn on litigation hold on the email server so no one could accidentally or intentionally delete relevant messages, protect the files too, tell the custodians to keep these documents, not destroy them. But Harvard didn't initiate a litigation hold until August 2021, more than 3 years later, even then only for one FRB member, the other 4 members not until I filed the case. What was lost in the interim? Well, Healy said he, quote, completely wiped his iPad in summer 2018, not 4 months after telling Noria I was likely to sue. That was an iPad that had his notes from relevant meetings where no one else took notes. We really need those notes. Meanwhile, Edmondson retained less than 32% of the messages known to have been sent to or from her, known because someone else kept a copy. In deposition, she said she's very disorganized in email, but that's just one more reason why her email should have been preserved at the latest in 2018. Now, some of her messages ended up in a remarkable double-deleted Outlook folder called Recoverable Items Purges, where messages go after being deleted, then cleared out of deleted items, and then I thought you press the purge button. Harvard says, well, actually, it can get auto-purged out of the cleared folder. Anyway, someone or something was clearing them, if not manually, then otherwise automatically, while the litigation hold was in effect. If the litigation hold had been put in place earlier, more would have been preserved. Finally, Stu Gilson testified that he intentionally deleted all his email. If he had been told in 2018 that he needed to keep the messages relating to the FRB, maybe he would have had more. There's lots more on this in the filings, including quotes from the remarkable messages that Edmondson deleted and cleared, but didn't quite get rid of. Some of those messages are awfully colorful. The evidence would have been useful. Edmondson has forgotten so much. In deposition, she even claimed not to remember attending the appointments committee discussion of my candidacy, though others who were there say she spoke more than any other single person. More documents would have been helpful to refresh her recollection, and where appropriate, challenge the facts that she and others now present. If you've made it this far, you must really care about me. In that case, thank you. Or maybe something sort of like this happened to you, in which case, first, I'm sorry, and second, I hope some portion of what I've told you here can in some way help. Or maybe you just want Harvard to be the beacon of integrity that you hoped it would be, rather than the disappointment that I sadly have shown here. Whatever your reason, if you've made it this far, check out the link on the screen. There's a whole lot more in the documents, and thanks for your interest and support.